And what is it with everybody in tacos this morning? Hey, welcome back, everybody. It's Law and Legitimacy, and for lack of a better thing, it's going to be called Taco Tuesday today. That's at least what the chatter on YouTube has to say. I'm sure on Rumble they're probably eating steak and eggs and cholesterol to go. So, all eyes on Washington. This week on Thursday, the U.S. Supreme Court is going to have argument on the disqualification clause case. That is the case arising out of efforts to disqualify Trump from even appearing on presidential primary or general election ballots because under Section 3 of the 14th Amendment, a person who has previously sworn an oath to protect and defend the Constitution, who thereafter engages in insurrection or provides aid and comfort to the enemies of the United States, is ineligible to serve unless Congress, by I think a vote of 2/3 of each house, grants him immunity. This clause of the 14th Amendment was passed and it was adopted as part of the 14th Amendment in the wake of the Civil War, some of these so-called Reconstruction Amendments, and obviously was adopted with an aim toward disqualification of those who had previously served as officers of the United States, and then served as officers in a breakaway republic that went to civil war with the United States, a civil war that ranged for some 4 years, cost 600,000 American lives, and threatened to dissolve the republic. The North won. The South adopted, or the South was brought back into the Republic, and those who were involved in nation building at the time were worried about a fifth column, as it were, people disloyal to the United States, those who lost in the battlefield, but might win in office if they were to be reelected. Does what force and impact should that clause have on our times? And that will really be the focus of the arguments on Thursday. And I spent a little bit of time yesterday on the Supreme Court webpage. It's called SCOTUS, Supreme Court of the United States, and we're soon going to post a how-to essay on our newsletter so that you too can learn how to find briefs at the SCOTUS webpage. But if you type in Trump versus Anderson, you'll get on the docket sheet part of it. A docket sheet is the table of contents, all the pending cases before the court, and then you type in on that case, you'll see the great number of amicus briefs, friend of the court briefs filed in that case. There are dozens of them, and so everybody and their brother has weighed in on this case. Thursday, the court has scheduled unusual amount of time for argument. I think it's 80 minutes or maybe 90, but the opening side gets 40 minutes. The other side gets a half an hour. And I think then there's 10 or 20 minutes for rebuttal by the opening side, arguments being split among several lawyers. And the question for the court will be, what do we make of the language of this clause? And it'll be it'll be a fantastic argument to listen to if you have the ability to do so, or to read about if you don't, because on display will be all of the architecture of constitutional interpretation. We have this language in Section 3 of the 14th Amendment. What does it mean, and what practical application does it have for our time? The question presented, what the court will be considering, is, did the Colorado Supreme Court err, or did it get it wrong when it ordered Trump excluded from the 2024 presidential primary ballot? How do you make that decision? Those of you who are lawyers know that reading the Constitution requires that you have a theory of constitutional interpretation in mind. The document just doesn't. I'm looking at a copy of the Constitution on my desk right now. It just doesn't say, "Hey, Norm, here I am. Use me." I have to go looking for it, and the tools that I use to read it sometimes determine what I see. So, for example, with respect to Section 3 of the 14th Amendment, what is insurrection? What does that word mean now? I looked it up this morning, and in the Oxford English Dictionary online this morning, insurrection is a violent uprising against authority or government. So, query, does the text of the Constitution require that that Trump not be eligible? Did he engage in insurrection? What does that mean? It's one thing to, if he had gone out and beat up a cop, let me into the chambers, I'm going to hang Mike Pence. That might be engaging in insurrection. If he merely benefited from it or encouraged it, is that the same thing as engaging in insurrection? Or is that offering aid and comfort to an enemy of the United States? Are people engaged in insurrection, civilians in a protest gone bad, turned violent? Are they engaging in insurrection? Are they enemies of the United States, or are they people who are just engaging in a riot? All of these textual questions will be addressed by the court, including what the meaning of the word insurrection meant at the time the document was founded. Sophisticated readers of constitutional interpretation texts and arguments will know that there are two arguments about originalism, for example, with respect to the meaning of words. What did the original writers intend, or what was the public meaning of the words they used at the time they expressed their thoughts in a written document, in this case, the constitutional amendment? So the text will provide some guidance. The history of its adoption will provide some guidance. Some will be inclined to argue that no, the history here suggests that this was a backward-looking amendment designed to disqualify only Confederates, those who actually took up arms and engaged in civil war. But others will say that's not what the text says. And the history is such that may be why the amendment was drafted and approved, but the amendment's text isn't backward looking, it's forward looking. And it's every bit as much a part of the Constitution as the First, Second, Third, Fourth, Fifth, Sixth, Seventh Amendment. It just happens to be named the 14th. Well, where does that fit within the structure of the Constitution as a whole and all of the other rights, guarantees, and privileges that it affords? And I think this is where the argument's going to be most interesting on Thursday, because implicit in the Constitution are things like due process of law, notice, an opportunity to be heard, fair procedures. No court has made a finding that Donald Trump has engaged in insurrection. No court has made a finding other than the Colorado court, which apparently concluded that he did. And so the question is, did they err? How did they reach that conclusion? Well, that was highly fact-bound. The trial court in Colorado accepted into evidence the House January 6th committee report that laid blame at Donald Trump's feet, but they did so without proof, without anything other than really a sort of political assertion that because he encouraged it, he caused it. And there's a difference between encouragement and causation. There's a difference between aiding and abetting and saying, wow, that's great, I'm not going to stop it. And so, these are all differences that matter. They're different. They're distinctions with difference. A lot of logicians like to say that's a distinction without difference. The car hit me. Was it a white car or a yellow car? That's a distinction without difference. Its fender print is in my face. So I mean, come Thursday, you'll see the court struggle with the text, the history, the structure. There's really very little by way of precedent, another important body of law that the Supreme Court has to deal with. And then they'll also deal with naked policy considerations. What are the consequences of any rule that we adopt here today? In highly partisan times, permitting state officers the ability to exclude someone from a ballot because of their evaluation of the person's conduct is a dangerous precedent that could have untoward consequences. So I predict that there's not going to be a unanimous decision, no surprise there, but I predict there'll be a narrow decision that tips in the balance of greater procedural protections and requirements for proof of insurrection or engaging in insurrection or aiding and comforting the enemies of the United States. And I predict
in particular, because what's being challenged here is one of the most fundamental mechanisms in a democratic republic, that is the ability to vote, right?
Well, and this is where it just gets purely delightful, Mike. Cass Sunstein recently wrote a short little book on how to interpret the Constitution. I've talked it up before, and I'm encouraging folks to read it. It'll be talked about at some length in our 4th episode on the United States Constitution, the informal little talk series that Mike and I are posting here. I'll do that one either today or tomorrow. And Cass Sunstein says the better school of constitutional interpretation is one, he suggests, of democracy enhancing norms. That's his theory, that when you look at judicial review, that highly contested ability of courts to determine what the law is, which is contested in and of itself. Andrew Jackson, for example, after the Supreme Court ruled in, I think, 1832 against removal of Cherokees from Georgia, what was Andrew Jackson's response? Well, John Marshall's made his decision. Let's see him enforce it. And then he ignored the Supreme Court because he took the view that under the separation of powers doctrine, each co-equal branch of government had an independent right to decide what the Constitution was for itself. Now, that would produce pure chaos when everybody disagrees. And so the way the law has evolved because of consequentialist reasoning is that typically we defer to the Supreme Court as the last and final word on the meaning of what the Constitution is. Sunstein takes aim at those who argue for originalism, basically saying, that the original intentions or public meaning of the founders or the adopters of an amendment is what should govern us in ambiguous cases. He says, that's a bad rule. What we need to have, we need to recognize the long arc of history, the moral arc or trajectory of history in favor of more democracy and transparency. Therefore, a theory of judicial review inspired by democracy enhancing norms is best. Oh, really? Are the liberal wing going to say that in this case? Or are they going to become originalists and say the public meaning was if you did something bad, you can't serve again? You're out, Donald. And oh, by the way,
that's the beauty of the Sunstein book, right? Is that you're going to find it doesn't matter on what side of the partisan spectrum you find yourself, you are going to indulge views that Sunstein presents that you fundamentally disagree with. And I found it to be so far. I haven't quite finished, Norm. But I found that to be pretty. There's nice parity in the positioning that Sunstein offers in the book.
Well, it is, and it's a great book. So it'll be a great set of arguments on Thursday. Looking forward to it. Unfortunately, I won't be able to listen to it live on Thursday. I'll be in the Connecticut appellate courts where we argue the Alex Jones appeal from the $1.5 billion judgment against him in the Sandy Hook case. But before I get there, I've got another appellate court argument in Connecticut today that I want to talk briefly about because it sheds light on what's at stake with respect to hate speech laws and how we evaluate prohibited speech. So you will recall that in January of 2021, we were coming out of a pandemic. There was a contested election. January 6th was a day in many states where new officers were sworn in. And in Connecticut, at the General Assembly, the legislature, protesters gathered to remind newly elected officials of what they thought was important. One group of them were folks protesting against medical mandates. And one of our clients, a woman named Julia Gilstein, emigrated to the United States from Russia, where she was subject to discrimination on account of her religion. She's Jewish. And she was protesting against medical mandates. A Black Lives Matter person, and she didn't have a mask on, a Black Lives Matter person turned up to protest and had a bullhorn. And there were a couple Black Lives Matter people saying, Black Lives Matter. And our client came up to her and said, no, all lives matter. And one thing led to another. And Ms. Gilstein, our client, spat at the defendant, and some of the spittle landed on the defendant's face. She sued. This was captured on a video, and she sued for assault and intentional infliction of emotional distress and so on and so forth. And so at a hearing, a so-called prejudgment remedy hearing, in other words, the plaintiff's lawyer, sought to attach assets of the defendants in anticipation of a potential courtroom victory. She produced an expert who testified, a sociologist from some tier 3 college, who basically said that the term white lives matter reflects a white supremacist movement and is therefore racist. And the trial court permitted this expert testimony. A former partner of mine tried this prejudgment remedy case and objected to the presence of the expert, saying this isn't what experts are for. And so the court granted a prejudgment remedy for about $300,000. And we took an appeal of that. And the issue that we'll be arguing this afternoon in the state appellate court is whether an expert's testimony about the meaning of words can ever show racial animus. Because one of the charges was that Ms. Gilstein had engaged in racial discrimination with her speech, and that her assault, the spitting, was animated by race, and therefore the plaintiff was entitled to treble or triple damages. Our claim is an expert can't take general terms out of popular art speech and attribute to them intentions that a speaker has. In other words, white lives matter might be a trope used by some people who are racist, but not all people who say it are racist. And in the Colorado, in Counterman versus Colorado, a recent Supreme Court case involving true threats, the Supreme Court said, wait a minute, we have to be very careful when we examine a person's culpability for criminal conduct, that we don't chill freedom of speech. And a person can only be found to have engaged in a threat if they had some subjective awareness that their speech was threatening. It's not enough to have an objective standard where some third party gets to decide what the thinker thought and intended. Our position in the case of an intentional tort, in this case assault inspired by racial animus, is identical to Counterman. And we're going to urge the appellate court to strike the expert's testimony and reverse on the grounds that this chills freedom of speech. We don't want Oprah, the people from The View, third-rate academics from piddling institutions permitted to come into court and offer their opinions about what words mean and must have meant to those who uttered them. That's for a jury to determine. And what's more, because of the importance of political speech in this country, it gives to plaintiffs and the state the ability to punish independent of a person's actual culpability or state of mind. So it's kind of, I didn't plan on talking about that. You don't see it in the show notes. When Mike and I were talking just moments before we went on the air, it occurred to me to talk to you about that. I'll report more on it, and I'll write an essay on it for the newsletter, because I do think it's an interesting issue.
Well, and just to review, this is a case that's criminal in nature, yeah?
Well, it's an intentional tort. So, the law, there's civil and criminal law. Criminal
Civil
law gets
case,
you
but
locked up.
intentional tort. Yeah.
Yeah, but an intentional tort meaning twisted, Latin, tortious, twisted behavior, law that society doesn't tolerate it, doesn't tolerate. So an assault is tort. It can also be a crime. In the civil context, at least in this case, if you engage in tortious conduct because of racial animus, you get treble damages, 3 times the damages. And so it's got a penal sounding or punitive sounding consequence, but it's not, in fact, a penal statute.
Well, and the reason I asked that question is just about the introduction of expert testimony effectively, right? Expert evidence, about the nature of, white lives matter and sort of the conclusory meaning of the phrase white lives matter. It's just insane, right? A total affront to the institution of law and justice.
Well, we'll find out. We'll find out what the courts think. I mean, I'm looking forward to the argument. It's at 2 o'clock this afternoon, so I've got a little time for the coffee to kick in. Thank you for letting me warm up here today. Get the words flowing. Yeah, what's going on at Northwestern? So parody. Satire. Northwestern has the Daily Northwestern or the Northwestern Daily. I don't recall which. And Northwestern and the paper's editorial policy is
Dailynorthwestern.com.
okay.
Yeah.
So the Daily Northwestern backs Israel in its dispute with Gaza. A group of campus wits, or nitwits as the case may be, decided to reverse things. And rather than have the Northwestern Daily appear on people's steps, they did the Daily Northwestern. And they did a mock-up of the newspaper in which the newspaper came out mocking, Israel and supporting Gaza. And now the Northwestern Daily, and it appeared, on draped over the regular image of the newspaper, and it has created quite an uproar on campus. And there is a criminal investigation. The criminal investigation. Yeah. Northwestern complicit in genocide of Palestinians, yeah, maybe. And so there's a criminal investigation going on. And the criminal investigation, apparently Illinois is one of only a couple of states that has a crime called theft of advertising services. So apparently the claim will be that by draping the satirical presentation of a mock-up newspaper over the real newspaper and distributing it to those who would normally read the newspaper, the satirists have in effect stolen the value of the advertisements in the newspaper. So you're selling Nike shoes to Northwestern kids, and you've got your shoe store advertisement on page 4 of the actual newspaper. Somebody drapes the fake newspaper over the actual newspaper and sells it. They've stolen your ad. That's a crime, apparently. I've never heard of that crime.
Yeah, so I'm looking at the Intercept article, and it says in this paragraph, I'll just read it for the audio only uh, viewers or listeners. Following the investigation, local prosecutors brought charges against two students for theft of advertising services. The little known statute appears to only exist in Illinois and California, where it was originally passed to prevent the Ku Klux Klan from distributing recruitment materials in newspapers. The statute makes it illegal to insert an, quote, unauthorized advertisement in a newspaper or periodical. The students, both of whom are black, now face up to a year in jail and a $2,500 fine. Now, interestingly, the word black, I've noticed this more and more, Norm. The word black, when referring to a person of color, must be capitalized. But also, we are not to capitalize the word white. Just throwing it out
Well,
there as well.
so, yeah, I hear that, and of course, we can't do enough for people of color. And let's not even go down that rabbit hole today. The
I will
the
admit, though, it is a rather obscure application of a law, right? Theft of advertising services. I guess my question would be, what else could they potentially be charged with? You certainly are usurping the dominion of an established uh, business, right? And that business is there some sort of first exception to the First Amendment for libel or defamation, right? By using that sort of uh, instrumentality or that channel of commerce that the Daily has established over a term of years or a course of years, and the expectation of their consumers of reliable information, et cetera, et cetera, et cetera. I mean, I find it to be an odd, awkward application of the law. I don't
I mean,
know.
I'm not sure it should be a crime. I mean, satire is obviously
Yeah,
uh,
and I'm asking
very
about civil tort here, right?
yeah,
Rather
but let's
than
break it
application
down.
of a criminal statute, but is there some sort of civil remedy that the Daily should have opted for, rather than and I don't know if the Daily had any hand in advising local authorities if they wanted the students to be prosecuted, that can go one way or the other. I don't know what the animus is on the part of local law enforcement to actually apply the criminal code, to these students. It seems like a mistake that they made, and they can atone for it in various ways, and the Daily is not without legal recourse should it seek it, right? So this is not doing anything to advance. I think uh, the cause of trying to resolve issues in American campus culture that we talk about on this stream, Norm, right? This is only going to further embolden those that feel that they are oppressed and targeted, that they speak for the underclass, the underprivileged, et cetera, et cetera, et cetera, right? The fact that the article, quotes the statute, but then says, "Hey, it was originally passed to prevent the Ku Klux Klan from stealing advertisements, but these two students are black." Right, and it's just an awkward. It provides an awkward narrative around what should be an otherwise pretty simple situation, I think, for the campus.
Yeah, I'm going to ignore the racial coding there and just say it's a misapplication of the criminal law. That there are civil remedies, and one might be a false lights claim. So, for example, the newspaper could sue saying you held us up in a false light. You adopted something that's that looks like our trademark. It was intended to confuse. It's on the same sort of typeface, and then you distributed it around our product in an effort to alienate our viewers and to get your viewpoint across, and it's contrary to ours. And so the tort of false lights is where you take someone's image, publicize it in a way that casts a false light on that person. But here's the irony. I mean, what's going to
And
what's
here's the answer to my question as well on the screen there, Norm. John Yates, the spokesperson for Northwestern, told The Intercept and Responsible Statecraft, quote, "The students' publishing company, independent publisher of the Daily Northwestern, pursued a criminal complaint related to the publication of the fake daily this fall. As required by law, university police pursued a criminal investigation, which led to a citation for violating state law that was issued to multiple students."
Well, I'd move to dismiss if I were representing those students on First Amendment grounds. Satire is a cherished exception to the First Amendment, and while I support Israel and am hostile to Hamas and think that if Hamas were exterminated, the world would be better off, I nonetheless support the right of people to obviously disagree and to do so creatively. I think criminalizing this conduct is criminalizing speech. It's unnecessary. There is an independent state tort, and they should use that tort and move on. We'll report more on this as it evolves. So somebody somebody tell me what's up with this Taylor Swift story. Taylor Swift, it is now being suspected by many, is a Department of Defense operator who's involved in a psyop, a psychological operation with Travis Kelce to co-opt attention during the Super Bowl to throw the election to Joe Biden. I mean, I read that this morning and my head exploded. You know, I said yesterday, and I said something yesterday that got secured me the gender-related scorn of Dawn. You know, I said something about a woman's attractiveness. Well, I'm going to, Dawn, here's the spoiler alert. You're going to be really upset in a moment. I don't get Taylor Swift. She has the sex appeal of an old ironing board, and I couldn't name a tune of her if my life depended on it. And I'm so tired of seeing Taylor Swift every time Travis Kelce or the Kansas City Chief do something with a camera cut, with a camera cut to the box she's sitting and seeing her smiling there. I came to watch the football game, not to watch the squawking ironing board, who I guess won a Grammy. But the notion that somehow people actually believe that she's a Department of Defense psychological operation. Like, what's going on in this country? Just how crazy have we become?
I don't know what people believe, but I will say this. Um, it's odd and it feels artificial, and there are plenty of strings and threads to follow to that end. What I've got on the screen here, Norm, is a very popular ad campaign that Travis Kelce, I guess his name is Kelce, which is another wrinkle
Okay,
in
well, I
all of
can't pronounce that either. All right.
exactly, right? So no one's ever heard of the alternative pronunciation of this tight end's name until all of this Taylor Swift, which is just another small thread where it's like it's something else to keep us talking about those two names. The widespread expectation, and I think that Jack Posobiec is largely responsible for the consciousness around this from the political right, the populist right. So we can credit him, good or bad, for creating a groundswell of I guess a general noticing of the Taylor Swift intersection with the NFL. But the NFL is America's most valuable entertainment export. Period. None of the other entertainment, professional sports leagues come close to doing the ratings, generating the revenue, or having the stickiness of the fan base of the NFL. So injecting Taylor Swift, and if you've watched any NFL games, Norm, which I did because I was busy winning fantasy football championships in paid leagues, not in the free ones that we set up here.
No,
Um,
where my team beat you how many times this year? But was it 3?
I don't know. So what became clear during mid-season, mid to late season is that the NFL, which owns all of its own broadcasting, right? NFL Films has millions and millions of hours of audio and video, et cetera. I mean, it is a very closed circuit environment, and they control just about everything that goes on within the entertainment aspect of that product that's on the field. It became clear that Taylor Swift was a clear marketing play for the NFL. Every time the Chiefs were playing and Kelce made a catch or caught a touchdown or made a, whatever it was, or there was a big play for the Chiefs, the cameras immediately made their way into the box in which Taylor Swift and her
That's a great
entourage
point.
sat, right? Every single time. So there is an aspect of sort of a synthetic.
And Mike, you know what else they were doing at that time in close association with that? Hawking touch football. And,
Well,
you know,
Well, and what they were
yeah,
also hawking is this commercial that I've got still framed on the screen for you, in which Travis Kelce is advertising himself as a double jabbed guy, right? Get your COVID and your flu shot. During all of these games, all of a sudden, Travis Kelce, after he pops up with a relationship with Taylor Swift, who's widely expected to put her emphasis behind the Democrat Party nominee if that ends up being the incumbent Joe Biden, right? And
my Joe
involved with
here.
big pharma.
Hi,
There's a ton
Joe.
here, Norm, that gives credibility
Hi,
to
Joe
people.
Biden calling.
But
Yeah,
listen to what I'm saying here. Listen to what I'm saying
yes,
here.
I'm Joe Biden.
Where
Okay, I'm sorry.
I don't know whether Taylor Swift is an op. I don't know that. And I don't care. But what's obvious is you have uh, a 34-year-old childless celebrity who has very outspoken political views that favor the political left, putting her weight and celebrity behind a very visible star athlete in the NFL who will now be in the Super Bowl after a season in which he was far off of what his normal records are, right? His normal averages. He's a dominant player. This year, he sucked, right? And the Chiefs as a whole have sucked, and they found their way to the Super Bowl, whatever. Now we get Taylor Swift in the Super Bowl. Okay? That's the point. And everybody is a little suspicious of the push by Big Pharma to put their money behind one of the most visible NFL players, NFL athletes who's now in the Super Bowl, right? And then a previously uninterested A-list celebrity, right? Who has an army of younger voters who really was encouraging people to register in the previous election, expected to put her weight and her attention behind the Democrat Party nominee in one of the most hotly contested elections in America's history, right? That's the story. That's the sight line that we offer you via sports. So the issue here is, okay, now we don't have the right to abortion was nullified, right, by the Supreme Court. And that's going to be an issue that she puts her weight behind. So again, this isn't just a coincidence. And the NFL's promulgation of all this is not just a coincidence. Now, is the NFL just
Hi, I'm Travis Kelce, and Taylor, you can abort my baby.
Sure. But what we know is that the NFL responds to criticism, right? Remember when Colin Kaepernick was wearing the pig socks and all the athletes started kneeling for the anthem and, that whole thing, right? You can turn on a game now and you'll not see any of that content, right? That doesn't mean that it's any different than it ever has been, but this isn't something that we should look at and just sort of scoff at. It's worthy of attention. I just don't know that it does a service to the people who are talking about it to say it's a PSYOP, a Department of Defense PSYOP. No, I just think that she's using her celebrity, and the NFL is using its desire for larger revenue from being able to increase the value of its ad space. They're taking the opportunity, and so is Pfizer, and so will the Biden administration when they encourage Taylor to put her endorsement behind a candidate du jour, whether it's the corpse of Joe Biden or somebody else, right? So
She's going to be the new spokesman for Quaker Oats. Oatmeal, the breakfast of champions, Hey, Dawn, what did I say that Harvard was so much better? I mean, I don't know. Maybe I did. Maybe I am an elitist, but my wife went to Harvard, so and my mother-in-law taught there. But I'm not so sure that I believe that it's that much better than all these quote unquote third-rate colleges. I'm sorry I offended you, Dawn. You're one of our valuable West Coast contingent, and I see juniors from Seattle. What is it with you people on the West Coast getting up at 5 o'clock in the morning to listen to this? I mean, there's you got a problem. I think either that or we do. Maybe we should move to the West Coast, Mike.
We've got a nice newsletter coming out at 9 a.m. today. So in about half an hour, our fourth issue of the LAL newsletter will be out. Norm, you've got a couple of really good pieces in there this week. Not that yours aren't typically good, but yesterday you spoke about an experience in court in D.C. for a sentencing of a J6 defendant. The story that you wrote, the essay that you wrote for that is in there. And then you've also got a really funny sort of some comedic levity, I'll call it, to the other, the criminal justice process where you found yourself in court where a courtroom was being vacated in emergency fashion because a criminal defendant learned some news that he didn't take very well, and then sought to take his one last hit before being incarcerated, and it created a panic in the courtroom.
Yeah, you just never know what you're going to see in court, and it pays to keep your eyes open, and it pays to have a sense of humor. Tonight, I'll be speaking at a Jewish fraternal organization. I'm a dinner guest at Yale, so I called the organizer, and I said, what do you want me to talk about? He says, tell people what it's really like to be a criminal defense lawyer. They get all this crapola at Yale. And so what I'll tell them is keep your eyes and heart open, because every day is a heartbreak, and every day is a laugh, and every day is a cry, every day is a tear. Criminal courts are life, and they're fun stuff. So take a look at the newsletter. Take a look at that guy who just had to get one last toke on his crack pipe, and hear what happened when he tried to light up in the presence of the judge. Didn't work out well for the guy.
You can subscribe to that newsletter at lawpoddaily.com. And you can also find our audio-only streams on Spotify, Apple Podcasts, Google Play, Overcast, wherever you find premium podcasts. We are live here, live and in full effect on YouTube, Rumble, and X every day at LawPodDaily, Law and Legitimacy on Rumble. And my only question, Norm, as I've begun to ask the last several streams, is who have you recommended Law and Legitimacy to today? Just an open
And
question.
another question we have is anybody looking for editorial responsibilities? As our empire grows, so do our tasks. We might need some help producing all this stuff. So if you know somebody who might want to be part of the evil empire, give us an email, and we'll probably ignore it, but at least you tried. So see you tomorrow.
See you tomorrow, Norm. Bye, everyone. Thank you.